You want to speak? All right, ladies and gentlemen, well, I appreciate everybody's patience while I was trying to hobble up here. This is the Subcommittee of Rules on Lawsuit Reform. And I'm Rob Leverett, and I'm chairing the subcommittee, and we are here today to hear Senate Bill 69. So the plan is to, I've got some folks who've signed up who want to speak in favor, and of course the Senate sponsor, the Pro Tem, is here. I was going to let him present the bill. We also have a substitute, which I've handed out to the members of the subcommittee, and I can, after the Pro Tem presents, I will kind of go through there and just try to highlight what the specific changes in the substitute are from the bill as it passed the Senate, and then we'll hear some testimony, and then we'll discuss the bill and try and take action. So, Senator Kenny, if you want to go ahead and present to us, please, sir.
Sir? Yes, sir. All right. Thank you, Mr. Chairman, and good afternoon, members of the committee. I appreciate the opportunity to present to you Senate Bill 69, which comes to you with significant support from the Senate. In fact, I think it was unanimous, if I remember correctly, coming off the Senate floor. So it's a good bill for your consideration. You know, last week we passed some historic tort reform that addressed a variety of topics that address some unfairness in our legal system. And today I bring you the second portion of Governor Kemp's tort reform legislation, which is focused only on one issue that has been increasingly problematic for not only Georgia, but for our nation, and that is third-party litigation funding, TPLF. For those of you that are aware, third-party funding litigation refers to a contingency arrangement between a non-party financier and a party or a potential party to a lawsuit in exchange for a property interest in the judgment of a case that has an expectation of a return. It is because it is within a contingency arrangement, it means that the financier may not realize a return or even a recoupment of the funds that are provided. TPLF largely applies only in funding arrangements with a plaintiff, as you would expect. It's important to note that TPLF is not a small industry, and it is growing annually. In 2023, analysts reported that the U.S. commercial litigation finance industry managed an estimated $15.2 billion in assets, with over $2.7 billion committed just in 2023. However, despite the massive scope of the industry in Georgia, TPLF is subject only to the contractual terms between the private parties, and there are no consumer protections in the arrangement in place for the plaintiffs entering into those arrangements. Cases brought by Georgia citizens who allege being wronged by TPLF funders have resulted only in the courts recognizing that the current laws applying usury limits or lender regulations simply don't apply in TPLF arrangements because these are not a loan. This results in a gap for what is essentially the same conduct as regulated lender entities, but the returns on the TPLF investments are contingent on the outcome of the claim, and that's the critical element that distinguishes these arrangements from what we all know and think of as a loan, and thus doesn't fall under any of the current regulatory structure that we have. Third-party funding litigation is basically unregulated gambling on our judicial system. There are no protections in place for the plaintiffs that enter into these types of arrangements. Cases in Georgia where consumers complain about their treatment show that there are no protections and there are no standards for these arrangements, and the courts are looking to the legislature to give some guidance. We have clear evidence of foreign involvement, which is yet another concern of why this needs to be addressed. Foreign involvement in our nation's judicial system, and it's getting to the point that the U.S. Department of Justice is highlighting that foreign entities are funding litigation to influence American domestic and foreign policy. Our Department of Justice is advising American lawyers and law firms to register as foreign agents when litigation is funded by these foreign entities. We have an obligation to give litigants and our judges the tools and guidance they need to uphold the integrity of our judicial system. I know that we can often get bogged down in lawyer bills, as we call them around these halls, but this is really a consumer protection measure, and it also combats the growing foreign influence in the judiciary. Mr. Chairman, if I could, I'll just briefly kind of run through by grouped sections. Section 7-10-1, which starts on line 28. And by the way, for the record, I'm looking at LC 492160 EC. Would that be appropriate, Mr. Chairman? Yes, sir. Yes, sir. This is line 29, which is it's the beginning portion, section 2, delineated as section 2. Okay. And I'll try to stay away I'll just go by headings and stay away from line numbers because I'm not going to get that specific unless you want me to. Basically, the first 4 or 5 pages really deal with definitions that begin on page 2 and go all the way to page 5. Until we get to section 7-10-2. That section requires litigation financiers that they must be registered. And you'll see in that provision, or that portion rather, that talks about what's required for the registration process and how that is to occur. The next section, which is 7-10-3, says that litigation financier may not do certain things. So it gives the prohibitions against what someone that's in this business may do or not do. I'll highlight one thing, Mr. Chairman, which is it's under 7-10-3A, subparagraph 4, which is line 192 if you're following along in LC 2160.
That's in 239 in the sub.
Okay.
Line 239 in the sub.
There's an important provision here that in essence it says that the contract for, receive, or recover, whether directly or indirectly, any amount greater than an amount equal to the share of proceeds collectively recovered by the plaintiff. This is in those items that are prohibitions, and in essence says that the litigation funder is not going to get and should not get more than the actual plaintiffs get net after the arrangement. The next section is 7-10-4 that says in essence that a litigation funder is jointly liable for sanctions. That's a short provision. It's only about a half a page.
That's 10-5 in the sub.
Okay.
The banking and finance added a section to the sub that would provide for denials of applications to be registered and then what the process is to appeal that. So the section you're talking of is 10-5 in the sub.
Okay. And the next section, 7-10-5 on mine, but I guess it would be 6 on yours, just basically says, the terms of an agreement of this nature should be in writing, and specifically goes forth and sets out what those terms, or at least some of those terms, must be. That's about 2.5 pages, and that gets us on over to 7-10-6 in my version. I guess it would be 7 in the sub. And this addresses circumstances where certain provisions would not apply to some arrangements where there may be funding being provided but specifically fall outside of the definitions that are set forth here. And then pretty much finally, Mr. Chairman, the last section talks about the penalties at 7-10-8, or would be 7-10-9, I guess, in the sub, that sets forth the penalty provisions in the event that if this becomes law, what would happen if there is a violation of what we are saying in this bill would be the rules of the road for litigation financiers as they deal with plaintiffs in that arena. That's a little bit of a high level, Mr. Chairman, but that is in essence what the bill addresses. Again, fundamentally, it is, number one, a consumer protection measure for plaintiffs, because right now those that enter into agreements with third-party litigation funders in the event that there is a dispute, and unfortunately there are cases in which there have been substantial disputes and some pretty egregious behavior on behalf of third-party litigation financiers that have taken advantage of plaintiffs, and those people find themselves in a situation without much remedy and virtually no regulation or oversight by the government, because it doesn't fall under banking and it also doesn't fall under the securities laws that we have. So with that, Mr. Chairman, I understand, as you've alluded to, that there is a sub. I saw it literally just a few minutes before this hearing. I'm not complaining about that, but because of that, if I could rely upon you, and I think you kindly agreed to perhaps point out for the committee the changes from what we passed to what is the sub for consideration today.
Absolutely, Senator, I'd be glad. And just for the committee's benefit, subcommittee's benefit, so the substitute basically preserves that first section, 7-10-1, that goes into page 5 of the sub. Then 7-10-2 does have a few changes in it. That starts at line 111 on page 5, and I think runs, on to page 8 maybe. Yeah, runs to page 8. On page 6, there is a change there in line 132. The percentage that sort of determines, sort of a disclosure requirement with respect to the ownership of the entity that's applying to be a litigation financier or the person. The threshold was 5% in the original bill. It's now been changed to 10%. I believe the Department of Banking and Finance said that is a more customary percentage with respect to triggering a disclosure, a beneficial owner requirement. And so that's been changed to 10% there on line 132. On lines 158 through 163 of the sub, that is the prohibition against foreign adversaries participating in litigation financing. They've changed that language there to try to make it clear that all the phrases that were in that section, foreign person, foreign principal, sovereign wealth fund, apply not to any foreign person, but just one that's affiliated or from one of the foreign adversaries. So we're trying to clarify this doesn't absolutely prohibit foreign involvement. It just prohibits involvement by foreign adversaries as they've been determined by that federal regulation that's referenced there. Then 7-10-3, which starts on page 8, that's a brand new section. Department of Banking asked to put that in. If you look through that, you'll see it basically provides when they can deny a registration to someone who's applying to be a litigation financier. If they don't meet requirements of the chapter, there's a prohibition there against someone who's got a felony conviction in the last 10 years who's involved in the financier, and then they define what constitutes a conviction. Then going on to page 9, they address the process if you are denied. There's a notice that goes out to the applicant, and they have a right to appeal it, and then the proceedings from there on are handled basically under the Administrative Procedure Act. So that entire section there is brand new. Then 7-10-4 was the old 7-10-3 on the bill as it came from the Senate. There are one or two changes there. On lines 232 and 233 of the substitute, there's a prohibition there in line 2 about paying commissions, referral fees, rebates, and that sort of thing. And this just makes it clear that they can do that with their own employees. They're just not supposed to give any sort of kickback in order to get work. And there's also the same exception was placed from lines 234 to 238. That's about accepting commissions, referral fees, and so forth. They excluded employee agents or affiliates of the litigation financier. All right, then the rest of that section, I think, was the same, I believe. On 7-10-5, I'm on page 12 now. that was 7-10-4 in the Senate bill as it came from the Senate. And this provides for joint and several liability for the litigation financier for any award or order imposing or assessing costs or sanctions against a consumer arising from the proceeding for which the financier has provided financing. This just sets a threshold of $25,000 or more in funding, and then provides that they would be jointly and severally liable. And toward the end of that paragraph in 278 to 281 says that where the financier's right of prepayment is a fixed amount set by contract, then their liability for the joint and several liability they have would not exceed whatever their right of repayment is, less whatever that has already been extended. Then I think we go through a couple of pages on the form of the litigation financing agreement, the required disclosures and provisions that are not changed. The exemptions are not changed. I think the next change is on page 17, line 409. That section is new, and that was requested by the banking department, so they can basically use their current sort of registration system and software to do this registration on as well. So that whole section 7-10-10 is new. And then section 3 is unchanged. Section 4, the effective date did change. They're basically saying here, or we're changing it so that the whole registration requirement and all of those prohibitions that are associated with it don't become effective until January 1 of 2026. That's because obviously it's going to take the banking department a little while to get all this set up, get the forms prepared, and get the word out there, and get that platform running. Section 3, which is the section that just provides that litigation financing agreements are now discoverable. This is amendment to the Civil Practice Act. That becomes effective upon approval by the governor, or becoming law without his approval, and applies to proceedings commenced on and after the effective date of the act or contracts entered into on or after the effective date. So the discoverability would apply sooner, but the rest of it won't take effect until January 1 of 26. So, Senator Kennedy, do you care to comment on any of those changes, or?
No, Mr. Chairman, I think I followed most of them.
Okay. There are a number of them, but they're largely housekeeping, and they're ones that the banking department requested just to sort of give them the required regulatory structure. And then there are a few substantive ones, like adding the $25,000 threshold and allowing, payment to employees of a litigation financier as opposed to, kickbacks and that kind of thing. So any questions for the senator? All right, I think I had Chairman Newton.
Thank you, Mr. Chairman. Thank you for your work on this. If you could help me at that last section 3, for lines 445 in our sub, they're the sections about litigation financing and the fact that it's discoverable, but it can't be used as evidence, but it is admissible. Can you help a non-attorney understand those two A and B sections of that? I know it's some that will apply to things that are 25,000 or more, it looks like, and then I'm just trying to understand how. Could you try to explain it to a non-attorney?
Senator, do you have the sub with you up there?
Yes, sir.
Okay.
And to be sure,
I
Mr.
would say
Chairman,
line 445. I'm talking about on the sub.
Mr. Chairman, to be sure, I'm looking at 492382 ECS. Is that right? Okay. So, Chairman Newton, let me look at that and try to. And some of this is new for me, but the beginning at line 445, in essence, this is I talked in my comments about the value of disclosure and transparency. That, in essence, I think this is the essence of that a party may obtain discovery of the existence of a litigation financing agreement as it's defined within this code section, which would be relevant to or subject to a particular pending action. What is added after the however is new language, And I would only assume that that is the purpose of that, is to have it be non-applicable to arrangements at a threshold of $25,000 or less. And then the B portion of that, which is lines 450 to 453, says information concerning the litigation financing agreement is not by reason of disclosure admissible in evidence at trial. And again, that makes sense, just because the standard for that which is discoverable by the parties through the discovery process is very broad and intended to be very broad. And then when you get to a hearing or a trial setting, that is one of the gatekeeping functions of the judge, is to narrow that down to that which the judge determines is relevant and admissible, meaning that it's appropriate for the jury to hear it or receive it as a piece of evidence. And I think this just reaffirms that notion that's baked into the normal evidentiary process.
That explains it for me,
okay?
thank you.
Yes, sir.
I understand now that there's one section that's purposely very broad in discovery. There's much more limitations on what's admissible to a jury.
Exactly. Yes, sir.
And I should mention too, I missed the last two lines on that page, the $25,000 provision that I guess you can obtain it from another party, but you can't go get it from the non-party unless if it's 25,000 or less. You'd have to be 25,000 or more for you to be able to use third-party discovery to obtain it from the financier. That is, I believe, new in this substitute also. All right, let's see, Representative Evans, I believe you were next.
Thank you, Mr. Chairman. Mr. Pro Tem, I really appreciate what you and the governor are trying to do here as far as consumer protection. Very, very much agree with the goal.
Thank you.
My question is about, it starts on line 366 of the sub, but I think it would be line 303 of perhaps the version you're more familiar with, even though I don't think that section changed. But it's the part where we're saying what provisions this chapter does not apply to. And it's got a section about a nonprofit entity. And then the third sort of exception is a regulated lender. And when I first saw this, I thought, well, what about Aunt Sally that lends money to her niece or nephew because they're going through a hard time and needs help to pay for whatever they need to pay for, attorneys or whatever. So my first question was going to be, do we really mean to haul Aunt Sally's family loan into this situation? I don't think we do. So this is a long-winded question, but I want to try to work through it with you because I think we have the same goal. When I flip over to the definitions of litigation financier, and particularly litigation financing agreement, that's telling us what's in here. And because the only things that are in here have to be a loan that's contingent on the outcome. And none of the things that we're trying to exclude in section, starting on line 366, are those things. So I'm worried about us being contradictory. I'm worried about us, I'm probably not saying this very clear, I'm trying to work through it in my head. Like, we don't normally say this is what this bill applies to, and then let me tell you these things that it doesn't apply to that are already excluded because they don't meet the definition. So I'm just wondering, do we really need lines 366 to line 388? Because everything in those lines are not loans that are contingent on the outcome, and we've already said this is about things that are contingent on the outcome. So can we just make it easy and make sure that we don't haul Aunt Sally into court is really my question.
Thank you for the question, and I appreciate it, and I appreciate your the effort to work through this to make sure we get to the right landing spot for this, because as you said, and I appreciate your comments that you agree with the policy that we're trying to meet here. I think because this is new, because this is unique, because we're talking about an animal out there that is a type of vehicle that is not recognized or regulated, and because we are getting into this area for the first time, I do think it's prudent to talk about what this is not. And I think that's why we do need section 7-10-7 identifying what this doesn't apply to. For example, your comment about the Aunt Sally loan, that shouldn't apply at all because it's a loan. And third-party funding litigation is not a loan. A loan has the concept that there is a repayment required. Third-party funding litigation doesn't have a repayment of the underlying indebtedness, it is an obligation to turn over funds pursuant to other contingent occurrences such as, or specifically, the litigation maturing into a verdict that produces a recovery. And so that's one of the ways, again, that I think we distinguish this and want to makes this a little bit odd. We're trying to address that. So I do think there's value, Representative, and utility in talking about what this is not. I think if we're going to address this, and we've tried to say this is what this business is, let's avoid unnecessary litigation and squabbling and fighting over, well, who's in the pool and who's out of the pool, by where we can think of those circumstances, identify these are specifically out. And I think it just adds clarity to what we're trying to do.
Sorry, it's okay. Along those lines then, in the sub on line 384, where we are trying to exclude a regulated lender that does not receive would you be opposed to striking the word regulated so that also a unregulated lender, the Aunt Sally example, that this exclusion also applies to her? Because otherwise, if a court's going to say, well, you told me what it was and then you told me what it wasn't, and you told me that a regulated lender it wasn't, but you didn't tell me that an unregulated lender it wasn't. And so I'm worried that the court will believe us, and I don't think you mean to include Aunt Sally.
So if you struck regulated, then you are broadening the definition of what is not included. Is that the objective? Is that?
Yes. And if Aunt Sally has a litigation funding contract that's contingent on the outcome, she's going to be included because of the definitions. So we're not bringing anybody, we're not excluding anybody I think you mean to exclude, and we are excluding people that I think you mean to exclude if we were to strike the word regulated.
Let me look in the. I think you gave me the line for the original bill.
Yeah, it's on the original bill it would be line 321.
Yeah, I believe that section was not changed.
Okay.
Or that particular paragraph.
Representative, my concern is, and I know so many eyes have been on this, far more than mine, obviously principally the governor's office, and I don't, in your Aunt Sally example, I don't think that's, I think that's clearly outside because it's a loan, so it's not included. My concern is I'm not sure of the import of how much this would broaden it to strike regulated from the document. And so for that reason, I would not want to do that without understanding or appreciating the potential ramifications of that in the moment.
Well, and perhaps there's a way to make another exclusion, but well, let me just make sure I am clear. You're not intending to wrap Aunt Sally's loan to her niece or nephew into something like this, into this bill.
No, because as I said at the beginning, what you're describing is a loan, and that doesn't fall under the definition of a third-party funding financier anyway. So
Right.
she's I think by common sense, by the definitions of the bill and by the other explanatory language, she's not included already. So I don't think there's a legitimate concern with her being wrapped into this.
Well, let me try to figure out then, maybe I agree with you, why do we have lines 384 to 388? Why do we exclude a regulated lender that does not receive, in consideration for loaning money to any person, a right to receive a payment, and so on and so forth? That's a loan too, right? Why do we exclude them and their loan from a regulated lender, but we're not going to exclude a loan from Aunt Sally? I'm just concerned how the court's going to read this, because if you say we don't need to exclude Aunt Sally because that's a loan and these are not about loans, to me, the exclusion we're trying to make in 384 is also a loan, and so the court's going to say, well, you excluded that one, but you didn't exclude hers.
Well, I think as a beginning point, if we try to identify everything we're going to exclude, this bill will be 1,000 pages, because we could come up with every possible permutation of things that are excluded. I think the original drafters of the bill, and those that have looked at it, from the banking department to other folks to our executive branch, thought for any circumstance in which there might be some argument that let's go ahead and clarify it. But again, back to your Aunt Sally example, that's clearly not included.
I would agree if we didn't have this exclusion section, but I appreciate you talking through it with me.
Sure.
That just, my whole concern is that we've said what it is, and then we've tried to say what it's not, and I think we could create problems for ourselves. That's my concern, but I appreciate your answer. My last question, Mr. Chairman, is about section 3. I think it's the last section where we are making things discoverable. And I just want to understand why are we making these agreements discoverable? I don't think a plaintiff would be able to discover how a defendant is paying their bills, and so I'm wondering, why does a defendant get to discover how a plaintiff is paying hers?
Sure. First of all, it's about fundamental transparency. As you know, as a practitioner, one of the questions we ask all the time in voir dire is, anyone that has an interest in the lawsuit or the outcome of the lawsuit. Clearly, a third-party funding financier does. It may be even something that the court will ask. As you know, in federal court, sometimes they will actually ask the questions of identify anyone that has an interest in the lawsuit. It would be extremely unfair and calamitous if we wound up with an owner of a third-party funding litigation company that sat as a juror on a case and nobody knew that his payday depended upon the verdict that he might help render.
No, I agree with you. So it is the parties that we're trying to get to, not necessarily the terms.
No, I think it's everything.
Why are the terms relevant?
Why are they not? If you're going to identify not only the parties, I think the terms of the document ought to be. I really would say the question is, why does there seem to be some fear in this?
And I don't mean to express any fear. I'm just trying to make sure we're being fair, because I know that you wouldn't get to discover how a defendant is paying their bills. I agree with you. We get to know who the insurance company is because we get to exclude those people from the jury. And I agree with you 100%. If somebody's got an interest in the outcome, just like we do voir dire on plaintiffs' lawyers if they have a contingency fee agreement, but we don't do it if they are getting paid by the hour. If their money depends on the outcome of the trial, the jury does need to know the people, because we need to make sure they're not one and the same or they're not related. I agree with you, but I'm having a hard time understanding why the term, and my concern is harassment. My concern is hauling all these people in here and asking people for discovery on how they're paying their bills and how they done this or that. That's my fear. My fear is not, I don't have any problem with the fairness you're trying to create, and I agree with you on that, but I'm trying to understand why the terms are relevant.
Yeah, the terms are relevant. I think two things. One, I don't see this getting into some sort of harassment territory. I mean, you're going to get the document that shows the terms. What could be or would be harassing about that? Nothing, I don't think. Number one. Number two, and I think, Representative, I think it's driven by addressing the fundamental problem we've got of the corrosive nature of this type business with these undiscovered documents and unidentified parties in our justice system. And what we have now are large hedge funds from foreign adversaries that are involving themselves in our civil litigation our civil litigation system, that can then create an imbalance because they are gambling on the results. I mean, traditionally our system is the parties go in, they are the ones that have something at stake. The plaintiff has been wronged and wants to be compensated, and should be if there's liability and damages. The defendant takes their position. You're now injecting someone else into the system that nobody knows who they are. Nobody knows what the terms of their document are. Nobody knows how motivated they are. And it's injected into our system, and it's not good.
No, I agree with you.
And again, I would turn the question. I think the real question is, why try to keep this? Why try to keep this secret, and why be secretive about it? There's simply no reason to, if in fact this is all fair and above board.
Listen, we are in agreement on the. I'm really not trying to disagree with you. I'm trying to understand why, because a plaintiff is not going to get to know, hey, Mr. Defendant, how did you afford to have that whatever, that briefcase. How do you afford to be here and not be working all day? How do you afford to have, 30 of your senior executives sitting in the front row of trial instead of working back home? How do you afford that? No one asked those questions, and I don't know why we're going to ask them to the plaintiffs. And I appreciate and I understand why we need to know about the parties, but I haven't heard the terms, and maybe we just disagree, but I haven't even heard a reason.
Yeah, and I think the short answer is in the traditional case, the jury is not asked to render a decision to financially reward the defendants. It's the plaintiffs, not the other way around.
Well, I'm not satisfied, but I hear the answer.
Well,
I had gathered
I'm doing
that.
my
I just
best.
want
I'm
to make sure you
trying
have
to-
a question. And I thought the chair might mention something. Was the lady's concern about the exceptions more the fact that it listing exceptions that might arguably be beyond the scope of the definition could imply broader applicability of the definition? So I wonder if rather than striking regulated, although that might be a solution, if we could add language just to make it clear that the listing of specific exceptions is not meant to broaden the applicability of definitions beyond their terms. That's just something I'll throw out that we'll think about.
Maybe so, Mr. Chairman. I guess and I appreciate the intellectual energy that the representative is putting into this to make sure we think about things so we don't wind up litigating or it produces a lot of unnecessary litigation because of some ambiguity. I fundamentally, I see the utility in here's what this is what it does, and here's a few things to be clear that it does not touch.
My assumption is the simple reason is there were some things that certain actors were concerned might be covered, and this is just to give them comfort that it's not intended to cover it.
Yes, sir.
But it does, I think the lady's concern is a reasonable one, although I don't know if we necessarily get there. I also wonder if there's maybe a way short of deleting the word regulated, if that's a concern, that we might still be able to address the concern. I was just positing that possibility. All right, I believe Whip Park was the next person whose light was flashing feverishly.
Thank you, Mr. Chairman. Mr. Pro Tem, want to bring your attention to lines 389 and 392 on the substitute, lines 326 to 329 in the original version of the bill as it passed the Senate. My question is, certainly with the substitute, we had a $25,000 materiality provision. With the original version of the bill, there's also due process for those who are registering as litigation financiers. With respect to, again, lines 389 and 392, it says any violation, however minor, would result in the underlying litigation financing agreement to be void and unenforceable. Should there be a materiality threshold or an opportunity to cure? Because if those provisions are not otherwise in there, where this would be an automatic penalty, does that not raise due process concerns?
Mr. Representative, maybe my version is different. You said any violation of this chapter, however minor. The words however minor is not in the version I'm looking at that you just added, so maybe I don't have the current version.
So the words however minor is not in there.
So you added that when you just read that. Okay.
Correct. But the bill does read as however minor, because there is no materiality.
No, it does not read however.
In application.
Excuse me, however minor. That's not in, that language is not in here.
So the word any, right? Any violation of this chapter, right?
Okay.
Again, are there any due process concerns related to not having an opportunity to cure the agreement, or would you be open to, again, some sort of threshold?
I think given the penalty structure that's baked into the bill that I think is fair and balanced, if we're going to have a good consumer protection measure in this bill that's driving this, then I think it needs to have enough teeth so that third-party litigation funders don't take advantage of plaintiffs that are in a position of needing the funds at the time. They're already in a situation they may be injured, they may be out of work, they're not in typically the best phase of their life that they have otherwise enjoyed. And I do think to give it teeth to this and make sure that there's a a penalty mechanism that makes sense, that will truly get their attention and not be overly cumbersome on everybody involved. I think the simple, straightforward answer is, or approach ought to be that if you violate this, then you're not going to be able to stand on this document and reap all the benefits that you thought you were.
I understand the importance of having teeth. I think it's more a constitutional due process concern that may exist with the bill without having an opportunity to cure an existing contract.
I don't think what you're describing, Representative, is a constitutional issue. Nothing about what you have described as your concerns, and you may just be thinking or seeing something here that I'm not seeing, but nothing about this rises to the level of a constitutional concern in my mind. I've not heard anyone else express that along the way that the path that this bill has taken. And I would also say, to see language as begins in line 390, any violation of this chapter is pretty common language we see in the code for other provisions, and I'm not aware of any constitutionality challenge or concerns with that general verbiage.
So a follow-up, if I may then, Section 3 allows these sorts of contracts, including terms, to otherwise be discoverable in ongoing litigation, certainly if this is enacted this year. During that discovery phase, if they find an aspect of the litigation financing agreement that does not meet the requirements of this legislation, would that automatically make that litigation financing agreement void and unenforceable? Because certainly I've seen other, aspects of state, bills that have this any violation, but not so much that it's automatically void and unenforceable. That's the part I'm struggling with a little bit.
Okay, if I understood your question correctly, you're talking about arrangements, whether they're contracts or whatever they may be, that don't fall under the provisions of this bill. So if they don't fall under this bill, then this provision that you're speaking of, lines 390 through 392, would not attach and apply to those type documents, contracts, or materials.
I don't think that's getting at my question, but
I'm sorry, maybe I missed. Could you restate the question? I'm happy to try to answer it. I must have misunderstood.
So again, my understanding of the application of this is that if there's any sort of violation, in my own words, however minor, the litigation financing agreement automatically would become void and unenforceable. If we are then allowing these sorts of contracts to be discoverable per Section 3, does that provide the defendant's attorney an opportunity to make null and void the underlying litigation financing agreement that a plaintiff may have entered into?
I would not think a third party can render a contract between two other people void, but they could make that an issue in the litigation.
That's what I'm struggling with. I don't see how the defendant has standing to even make that argument or assert the position that a contract to which they are not a party is impaired or ought to be voided.
Then how would this then otherwise be enforced?
It's enforced because if in fact the plaintiff, who's the consumer, who's the contracting party with the third party litigation funder, if this contract violates public policy, violates Georgia law, they have the right to say, wait a minute, this contract is void. They are the contracting party, the plaintiff is.
Thank you.
Thank you, Whip Park. I believe Chair Lady Miller.
Thank you, Mr. Chairman. Thank you, Mr. Senator Pro Tem. Speaker Pro Tem, Senator, President of the Senate, Co-President, Vice President.
Whatever.
I do just, and thank you for the bill. I do appreciate any effort to protect consumers and have traditionally been concerned with sort of the disparity between consumers, working people, and banks and lending institutions, et cetera. So I do thank you for the thought that went into this. And this is more a question of curiosity than criticism at all, really. But for a person who is not as familiar as lending industry, guardrails, rules, regulations, would you say that the limits that are being imposed on third-party lenders here are similar to any other place in our code where we impose restrictions on lenders?
I'm sorry, any other what?
Place in our code, say traditional banks or anything like that? Is this sort of modeled on something that we already see?
I don't know that I would say it's necessarily modeled on something we see in the code, because as I said earlier, it's not a loan, so this type, this device, if you will, doesn't check those boxes, so that you would then expect to see some other model that dealt with this. It's not a security. That was the other thought we had. Well, maybe this should be in the securities code. Should it? Is this kind of a security? Well, it's not that either. I would tell you that there are some third-party funding litigation bills that are getting passed around the country, and I think there's one from Montana that was passed last year or year before last. But that's not really what you're asking. I think you're asking me, is this found elsewhere in the code? I don't know, quite frankly. The governor's office, who did the yeoman's work on drafting this, might have an answer for that, but I think the real answer is probably not, because we're dealing with an animal that, and quite frankly, we as legislators are here to address this, because it is totally unregulated, totally unaddressed in the law, and that's where we're seeing, arguably, why we're seeing maybe some abuses out there, and why we need the consumer protection measure.
Sure, and I support that. I will, though, say that, in my experience, sometimes plaintiffs just simply cannot afford to finance litigation, to finance medical expenses when they're in pain, and unfortunately can't get traditional loans. So I am not opposed to regulating this industry, obviously. I am just wanting to make sure that we are making it fair to consumers, and not keeping consumers from something that might be valuable to them. One of the things I was curious about was a section that was added in the sub dealing with directors, officers, etc., of the entity who have taken a first offender plea. And I was curious about whether that, what's the rationale for that? So why would we say that they cannot, ipso facto, because they took a first offender plea within the last 10 years, not be able to engage in this kind of business, assuming they cross every other T, dot every other I, behave exactly the way that you want them to behave under this bill? Why are we cutting out that class of folks from engaging in this business?
Can you point me to where that
Sure.
is, and is that
in
in
fairness,
Yes.
that's new. I'm not sure that was necessarily Senator Kennedy's
Oh, okay.
innovation. I
That's
think I can answer that question.
Mr.
I believe
Chairman,
that came
please.
from the banking department, and that is, I think, fairly common in the banking regulatory space, like for directors and officers of a bank. If they have any kind of felony conviction, even if it was a first offender plea, that generally can be a disqualification from serving as a director or getting a bank charter started.
Understood.
So I think they were just modeling on existing regulatory or statutes that set up some regulatory framework that they're familiar with, so they can administer it more
That's what I was
easily.
trying to figure out. Thank you, Mr. Chairman.
That's a good question.
Thank you.
Thank you.
Chairman Newton, I think you.
Just a quick question. Thank you, Mr. Chair. And you kind of answered it. I was going back to the regulated lender and the fact that we did get information, this informed somewhat by the banking department as well, since this is a type of loan. I'm just curious, to regulated lenders, I'm sure, have certain written document requirements. I'm assuming unregulated lenders would not have the same level of documentation, and therefore, I guess maybe if banking input was in this, regulated is the only one where you're required to have written documents that could be reviewed.
That certainly makes sense.
I'm assuming
Yes.
an unregulated lender, we don't have a lot of control over, I guess. Is that right? All right, thank you, sir.
Representative Evans?
Just to follow up on Chairman Newton's point, if that's true, then perhaps one way that we can make sure that we don't disrupt Aunt Sally and have her called in for a deposition on her unwritten loan agreement is that we limit Section 3 to written discovery.
I'm sorry?
Is that
So
we
that-
limit Section 3, the discovery part, to written discovery. Because
Well-
I just take Chairman Newton's point.
Yeah, I wouldn't agree with that because we're back to the point, I think we all agree. I don't think anybody says that Aunt Sally's loan is subject to this, and it's not.
I agree, which is why I don't know why you don't want to say it. That's my confusion. I agree. The definition of these agreements, and an agreement doesn't have to be in writing. The definition of agreement doesn't include Aunt Sally. But when you go to another section of the bill and you start saying who it's not, and you won't allow us to put in the word, or you don't agree, we could still try futilely, but you don't bless a change to make sure that we don't also exclude Aunt Sally. I don't understand that, because if these people that got excluded because they were afraid they were going to be included, I don't know why we're so scared about making sure that we exclude Aunt Sally. That's my point.
And I get that. I think the difference in my mind from these type folks that are referenced in here in the specifically excluded category, unlike the Aunt Sally circumstance, because it's a loan, it's out already. And so I think
How is line 384 not a loan?
because, well, it says a regulated lender, but it may be a lender that's engaging in third-party finance litigation in which it's not a loan. And if it's not a loan, perhaps you're into the gray area where this might be subject to it.
It says a
Because-
regulated lender that does not receive in consideration for loaning money to any person. It's excluding a particular type of loan from a regulated lender. I'm just trying to make sure we also exclude loans from an unregulated lender, and I
Well,
don't
the-
understand the hostility to it.
The other concern, if we're gonna exclude Aunt Sally, then are we going to open up the possibility of individuals that want to get into this business in a way that skirts the regulations? They may not be a family, but it's an individual that wants to skirt the regulations. And again, I think the clarity is here, and it, to me, maybe it's just conceptual, but as a beginning point, Aunt Sally is making a loan, and they're excluded.
Just
as
like
is
just like the regulated lender that we're excluding in line 384 is making a loan.
And again, we can have a 1,000-page bill if you want, and think of every possible scenario.
I definitely don't want a 1,000-page bill.
Okay,
I just
and
would
neither
like
do
some
I.
intellectual honesty in considering amendments, that's all.
Well, I think we have an impasse on that issue, but I think the lady's made her point, and I think the senator has responded with his perspective as well. That's, in my mind, that's something we're still thinking about. So, Representative Miller.
Thank you, Mr. Chairman. One other thing, just as I'm trying to process what I really like about this bill, and I just want to make sure we don't have any unintended consequences. The section in the sub that allows for the litigation financer to be jointly and severally liable for any award or sanctions for frivolous litigation that might be imposed against the, I guess, the plaintiff's lawyer or the plaintiff's
So that's lines
case.
272 to 281 of the sub.
Yes, Mr. Chairman.
Thank you.
With the point made in the bill that the litigation financer is not permitted to participate in the litigation, not permitted to attempt to influence resolution of the case, and really has no function, which I think the bar rules probably would prohibit this anyway, but what would be the rationale for making a litigation financer who's doing a good job, who's following all the rules, who's being fair, and some attorney does something in court that the litigation financer had no say in, and they get hit with a sanction that the litigation financer is now on the hook for that? I mean, I guess I'm just trying to, is that designed just to keep people out of the business of doing this, which I'm not sure what we're trying to do. We just want to regulate it. What is the fairness of that, assuming that the litigation financer is otherwise abiding by, the regulations that are addressed in this bill?
Sure. I think, number one, you've set up a hypothetical that's probably not going to be realistic, or no way to determine, did the third-party litigation financier, were they totally excluded? Did they never involve themselves? Did they not participate in the decisions? Did they not bring pressure? And so I don't know how you get to the bottom of that other than making it clear that they are subject to being jointly and severally liable, number one. Number two, I think some of the concept may be behind if there's going to be some sort of award that's monetary in nature, the plaintiff may not be in a position to satisfy that. Number three, this is clearly, again, kind of a unique animal, right, that we're talking about. It's not a loan. It's not a security agreement. And because of the closeness of the nature, I think, of this business arrangement where they are partners, if you will, on enjoying whatever the fruits of the final result is per the terms of the contract, I think to say that if they're going to be partners and share on the good side, then perhaps it ought to be also on the bad side as well. I think that shows some consistency and equity across the board.
I think I do understand your rationale. I just don't, in my experience, I've never seen it, having had clients who had litigation financing, having used it. I have never had a litigation financing, maybe they were all just the good guys, attempt to tell me how to run my case. I mean, it just doesn't happen. And so what I'm hoping, what I think you're trying to do is discourage these bad actors who apparently exist from otherwise interfering in the fairness of the process, having an interest in the process and using that to influence it. And you do that in the bill. So why would we then assume the opposite of what we have legislated here? And why wouldn't we assume that the folks are going to abide by the statute, assuming it passes, as opposed to assume that they haven't? I mean, wouldn't it be better to have some showing that this litigation financing bad actor did those bad things in the bill, as opposed to just assuming that they did just by virtue of being a litigation financer?
No, I think it is a fair approach for this reason. I think the nature of the arrangement between the financier, the plaintiff, and the plaintiff's counsel, who's typically a part of that, is one such that it's going to be extremely difficult, if not impossible, to get to the bottom of exactly who took what position, who advised, who relied upon that advice. You've got a one-directional attorney-client privilege of the three between two. That's typically not going to extend unless the lawyer also happens to represent the third-party financier. I don't think that would be appropriate, but it may not be a technical conflict under our ethics rules. So you've got just a very strange combination here.
I get it in your hypothetical, but I guess in reality, if the lawyer gets sanctioned in court, the lawyer's not looking around for anyone else outside the court. The lawyer bears the responsibility for his or her behavior in court, the decisions about claims to bring, the decisions about, as an officer of the court, how he or she conducts themselves. That belongs to the lawyer. If a lawyer gets sanctioned, why are we going to just assume that somebody else who otherwise was abiding by the rules should be on the hook because in our hypothetical or in our imagination, we can't imagine that they wouldn't have known? I guess I'm just having some trouble following the logic on that.
Sure, and I understand that, and again, I appreciate the question, but I would also further add, what you see here is not inconsistent with many of the attorney's fees statutes, such as under 91514, where not only the party and the lawyer can be assessed attorney's fees for the conduct, for the frivolous litigation, or the unnecessary expansion of the proceedings. And there are other statutes where both the party and the lawyer can be found responsible. This is not inconsistent with that.
But doesn't there have to be a showing? I guess it's not automatically assumed, which is what this section of your bill does. I mean, there has to be some affirmative showing before we hold someone on the hook for conduct that they may or may not have participated in.
And again, the difference here is that the third-party litigation funder is functionally, financially, a partner in this endeavor because it's not a loan.
I think what they are is they have made a deal. It is a high-risk deal. They are essentially, in a lot of good ways, let's not just make them all bad guys, in a lot of good ways, they allow for people who cannot afford what it costs to bring a case to actually bring that case and have their day in court. I have never, not in my more than 20 years, I'm not going to say how long I've been practicing law, a long time, seen a situation where a third-party litigation financier is telling a lawyer what to do in court. In my experience, I've never seen it. And so I guess that's why I'm struggling with the scenario that has some, DC bureaucrat in some litigation financing company telling a lawyer what to do in that lawyer's case when that lawyer, him or herself, doesn't get paid unless they get it right. So they're going to do what they think in their judgment is going to be the best interest for their client, especially if they're working on contingency. They're not just taking orders from somebody because they put money to finance a litigation. I have never seen that. Perhaps you've had different experiences. Thank you, Mr. Chairman.
And final point, they would unless their contract gave them that authority. And that's what we're trying to do, to make sure that these third-party funding and litigation agreements are fair to the consumer.
Perhaps would the gentleman consider on lines 274 changing shall be jointly and severally liable to may be jointly and severally liable, and allow for some assessment of whether or not imposing that sanction is appropriate under the facts?
That's up to the will of the committee. I would not want to see that change made, again, because of the nature of the arrangement. And I get, fortunately for you as a practitioner, you've seen the good part, the good third-party funding litigation, folks. But as we said, I think you made the comment earlier, really what we're trying to do is make sure that the bad actors aren't taking advantage of consumers, aren't taking advantage of plaintiffs. Thank you.
Thank you for the question. I would say I sort of shared some of the ladies' concern here, but my assumption, and we know how dangerous that can be, but my assumption, just trying to sort of think through what the likely policy was, is if you're engaging in litigation financing, in a sense, you're almost becoming a partner with the firm, and it's customary where you're in a partnership, you have sort of joint several liability. Doesn't necessarily mean we have to do that here, and I understand the lady's concern about doing that, but that was sort of my view of it. And I think it also makes sure that if you're going to provide litigation financing, you're going to do it with good cases with reputable firms, and it just sort of encourages that certain regulatory approach to it. So that doesn't necessarily address the lady's question, I know, or concerns, but that was just my view of kind of what the overarching policy consideration might be there. So, all right. Well, I don't see any further questions. Cindy Kenny, thank you so much for presenting your bill to us. I do have some witnesses we want to hear from. I've got 4 folks who want to speak in support, and I would just like to limit you to like maybe 4 or 5 minutes if you would, and I'm just going to call on you in the order you signed up. So the first person is Jack Kelly. I think you've got Senator Kenny as sort of the example. Just go over there and make sure you get on that microphone good enough.
I appreciate it. Is that good enough for you, Mr. Chairman? Can everybody hear?
Can you pull it a little closer?
When you're my height, you have to put a lot of things closer to you.
Yeah, just lean in a little bit to it if you would. Thank you.
I appreciate it. Thank you, Mr. Chairman. My name is Jack Kelly. I'm Managing Director of the American Litigation Finance Association, which is a trade association of the oldest and largest companies involved in consumer litigation funding. And I reiterate the term consumer litigation funding. My members do not provide any money to any individual that is used for the purpose of the prosecution of litigation. I'm fortunate enough to be an adjunct professor at Fordham Law School, and I often, when young law students ask you questions, and you use the term prosecution of litigation, they say, well, what exactly does that mean, Professor? Well, that means that the money that you get is going to be used for court fees. It's going to be used to pay lawyers. It's going to be used to pay witnesses. It's going to be used to even pay people getting back and forth to the courthouse. All sorts of things that all are used for the advancement and the prosecution of the litigation. My members do not do that. My members are involved in what's known as consumer litigation funding. It is a funding transaction where an individual involved in a personal injury case, you're down Muskogee County, and I use Muskogee because I'm proud to have spent a large portion of my life jumping out of perfectly good airplanes down there and spending a lot of time in Dahlonega crawling through the mountains. But somebody down in Muskogee could be involved in a car accident, and they need money to get the car fixed. Or they might be out of work for just a few days, and they work for themselves. They don't have other money coming in from their company and getting workers' time or anything like that. And they need a small amount of money, maybe $3,000, to be able to get their car fixed. Or suppose they have a farm. They've got a 150, they need to get it repaired, because they can't go down to the feed store and get feed if they don't get it repaired. That money is given to them, put into their pocket, and contractually prohibited from being used for the prosecution of litigation. The legislation here today is good. I want to commend Senator Kennedy. ALFA, the American Legal Finance Association, has been around the country I've been around this country for the past 10 years, working to adopt legislation that regulates this industry. Our companies, which are the largest funders, we don't want bad apples in this business. We don't want people creating reputational problems for the people who do it right. We've worked with even as progressive organizations as the CFPB, and kind of shiver when I hear that, to get model contracts. Well, the problem is that the way this legislation is written, it's good. It's adopted many of the things that we've adopted in other states. But it has some unintended consequences. And one of the unintended consequences in the substitute is at page 5. It has on line 106, I would like to add a provision, which would be Roman numeral 6, because the way this is written as a definition of a litigation financier, if a pension fund or a financial institution provides money to a company to just pay their payroll, to pay basic costs, just basic finances that are arranged for a company to operate, you would be defined as a litigation funding company. You would be defined as a litigation financier. You would have to get registered with the state of Georgia, and you would have to go through all the requirements of this act. That is not what it's intended to do, and I appreciate everything that's been done here. But the problem is that this unintended consequence would create that phenomenon. Every state in the United States that's adopted litigation financing work that we've worked in to deal with consumer litigation has adopted this provision. The National Conference of Insurance Legislators, who did their Model Act, which much of this is taken out of in definitional terms, includes that exclusion. So the exclusion that I would ask to be offered in an amendment would be at page 106 to add subsection Roman 6, and it would say the term litigation financier does not include banks, institutional investors, and persons that provide financing to a litigation financier but do not engage in the business of litigation financing. We think that, again, as I've said, the work that's been done by Senator Kennedy, the governor, and the people, and particularly the amendments that have been included here today in this substitute, have recognized many of the problems. But I urge and I ask the chairman and the members of the committee to consider and to adopt that singular amendment, because we do not want to be able to preclude a company from being able to get basic financing to do their payroll or to pay their rent or things like that.
So is the exclusion you're seeking one that says the lender for the litigation financier is not a litigation financier?
Yeah, it says that the term litigation financier would not include a bank, an institutional investor, a person that provides financing to a litigation financier but does not engage in the business of litigation financing.
All right, I guess my response, I understand the desire for the exception, but if you're not engaging in litigation financing, you're not subject to the act anyway.
No, the problem is the way it's defined, it would. That's the challenge. So if we
But
go
it
to
seems like a
definition of-
tautology. You're saying an entity that doesn't engage in litigation financing ultimately.
Can I go to, I'd have to go to definition of litigation finance. A litigation financier means that any person engaged in or form, created, or established for the purpose of engaging in any kind of business or economic activity that involves providing litigation financing. So that would be economic activity provided to the company that does it. That's the expansion of the use of the term economic activity. An economic activity would be funding a financing company.
I guess that's the issue, I
Yeah,
suppose.
and I don't want to touch the definition of litigation financier, Mr. Chairman. That's a well-defined term, and has been included in the other states that have adopted this, such as Montana, that the sponsor offered. This is well established, and I do not do this out of trying to offset the hard work that's been done here today, Mr. Chairman.
Thank you. And so I guess, is it your position then that the kind of financing you provide to the individual plaintiff would not be caught within the scope of the definitions here?
Would be, what our companies do would be, the way the broadness of this definition, our companies do provide, the way this is defined, because we provide money that's contingent upon the success of the case, they would be captured. What I'm talking about is the companies that provide money to us to fund our own companies, meaning to pay for our rent, to pay for our salaries, to
That
pay for
provide
things like that.
financing to you, to
To
your
you,
company?
to our companies,
Okay.
not are provided to the consumer or to the plaintiff.
Okay.
And that's why the exclusion at the end of my amendment says, not engaged in the business of litigation financing.
Okay, all right.
So that just buttresses what was said in the definition of litigation financier, but because of that economic term in there, it could accidentally and unintentionally capture them.
Okay.
And then what would happen is a company would turn around and say, I can't provide you money because I don't want to get registered in Georgia.
Okay. All right. Any questions for this witness? I don't see any questions.
I appreciate it, and again, I'd like to thank the committee and the members, and I'd like to thank Senator Kennedy for his hard work.
Thank you for your testimony. Pam, is it Bracher? I think I tried to make you like Dr. Charles Brocker in Athens last time, and I got it wrong.
No, sir, I think you got it right this time.
Okay, good.
Thank you, all of you, for letting me come back again today. I am here on behalf of the American Trucking Associations and the Georgia Motor Truck Association to speak in support of SB 69 and the consumer protections it brings to the citizens of Georgia who may seek the assistance of third-party litigation funding. Real briefly, before I go into some of the remarks that I prepared, I saw one of the committee substitutes that would limit, because I want to speak solely on the discoverability of these agreements, that would limit discoverability to agreements 25,000 or more. One concern that I do have with that amendment is that unscrupulous litigation funders will take advantage of that, and instead of, for example, offering a funding arrangement with a plaintiff in the form of one agreement for $50,000, they'll do 5 agreements for $10,000. So I would encourage you all to consider that type of loophole that might be created with that amount. But in the context of personal injury litigation, it's certainly the unchecked consumer litigation financing that could pose a threat to our civil justice system. People who are victims of some negligent activity and are injured are often financially strained when healing and going through medical treatment. And so being able to access litigation funding may be a form of liquidity that brings them some benefit. But however, in this area of consumer finance, which I could make the argument there are some similarities with payday loans, it should be regulated and subject to consumer protections because there are bad actor predatory lenders in the third-party litigation funding space that could further harm these plaintiffs. We see in some of the post-funding arrangement litigation, we've seen percentages that are 10 and 11 times, or create an obligation to pay back in an amount 10 or 11 times and even more sometimes, the original loan amount or the original funding amount. Third-party litigation funders are providing litigation funding as an investment, and although it's unlike stock market or other investment vehicles, they expect to make a profit on their investment. They offer high returns to the funders and uncorrelated to the price movements of other investment vehicles like stocks and bonds and commodities. They charge high interest rates to offset the risk of no return if the litigant is not successful, and the often long-term nature of these funding arrangements, since lawsuits take several years to resolve. Litigants' interest in obtaining funding to assist with expenses paired with the funder's potential for a significant return on the investment have definitely sparked the expansion of the business model. The consumer protections in SB 69 will bring bargaining equity to the borrower and the lender, as it should be. With respect to discoverability, though, without seeing the funding agreement or knowing who the funder is, we don't know who the anonymous third party is or if or how they might be controlling the claim. Again, we know from litigation that has occurred between consumers and the lenders, we've known because in those lawsuits the agreements have been produced. And so despite assertions of the third-party litigation funding company to the contrary, the production of those agreements in those consumer litigation lawsuits confirmed that there are occasions where the terms of the agreement did give the funder some measure of control and or active participation. And so there's no way to know whether the funding agreement is one where control exists or does not exist without disclosure and the opportunity to review the terms. It's the only way to know whether or not the funding transaction is proper or improper. Right now, under current law, Georgia state court judges are presiding over lawsuits in which, unbeknownst to the court, a non-party investor has a direct contingent financial interest in the proceeds produced by any judgment or settlement due to the litigation funding. Courts are in the dark and unable to assess whether there are conflicts of interest at play in the litigation that they are overseeing. Courts in other states have shown, again, and this is in litigation between the consumer and the funder, they have shown that disclosure of the healthcare financing agreements, which are a subset of third-party litigation financing agreements, may be relevant to questions of damages or cost of medical services provided or even witness bias. In addition, continuing communication obligations between the attorney and the funder can create a potential conflict of interest, and sometimes the consent of the client has not been properly achieved or obtained. And if the funder is providing funding to several of the attorney's clients, there's an ongoing business relationship that could present an additional conflict of interest. Funding agreements sometimes lay out how the funder will be paid, and in many known instances, the funder takes the cut first before the plaintiff is paid. This puts the investors ahead of the plaintiffs. And in some agreements, there is the allowance for funding to be used to pay part of the attorney's fees, which could also create additional ethical considerations around the representation. Just real quickly, they just the acknowledgement that they do change the litigation dynamics, and it does create incentives or disincentives. And so right now, under the current law, we don't know the true societal cost of third-party litigation funding because we can't confirm, since we don't know the agreements or how many agreements or who's involved, whether the funding is encouraging more litigation or not.
All right, thank you. You have a question, Representative Evans.
Thank you, Mr. Chairman. Thank you for being here. I understand the need to know the party. I understand the fairness, and the court deserves to know, the jury deserves to know. So we're going to take care of that. The bill also takes care of a litigation financier being able to run the show, because it says you can't do that. You can't be involved in any decisions. Is there any other terms that you can think of that you need to know?
So,
and why?
First of all, I want to say I guess that I have not been as lucky as perhaps you all have been in your litigation practice. I have been involved in scenarios where people have represented a certain course of action. They have said that they are not doing something, and then when in fact I get the document, I found out that they were doing something opposite of what they said that they were doing. So I guess I come from it in a place where sometimes people aren't always telling the truth. So there's that. But as I mentioned in my comments, litigation between consumers and funders that have occurred where the terms of the agreement has been produced, those terms have sometimes shown ethical problems, conflicts of interest because of how the funding terms were drafted in terms of how payment was made, who's paying for expenses. And then within this special subset of healthcare financing, it does sometimes disclose whether or not that treater had a bias to recommend certain procedures that may or may not have been as mandatory as that provider made it out to be. So the court was able to get into some of those potential biases and conflicts of interest.
And that was something that you were able to discover. I mean, obviously, this is not law today. You didn't have any. It sounds like you've had a lot of experience of getting access to agreements.
No, it has been difficult in the litigation that I was involved in Louisiana. Louisiana just passed their law, which has some striking similarities to this, including the discoverability pieces of it. But that I was involved in the Operation Sideswipe cases in Louisiana that you may be familiar with massive indictments of attorneys and healthcare providers and folks that were staging accidents against commercial motor vehicles. And so the efforts to get those types of discovery, it took us a really long time. And it wasn't until the criminal investigation, as I recall, the timeline came to place where we were able to get some of that disclosed to us.
Right. Well, and that sounds awful, and it sounds like it would all be very directly relevant to the parties that were at issue there. Any examples of problems in Georgia that you can share with us?
I have not had any problems in Georgia.
Thank you.
Thank you, Mr. Chairman, and thank you for coming back to speak to us today. I'm not sure if you answered this question, but I'm trying to understand. Let's say you're provided with this third-party litigation financing agreement and discovery. What do you do with it?
So when you do the agreement, I don't think it's any different than what you might do when I give you my insurance policy as a defendant. You're going to look over the terms of the insurance policy. I'm going to look over the terms of the agreement. I'm going to understand who is the party to that policy, that agreement. I might do some research about that funder. But other than that, I just put it aside. And then when I get to mediation and we start talking through possible settlement scenarios, I make sure that all of the key stakeholders that should be involved are involved. And if that funding agreement tells me that somebody should be participating because of the terms of that agreement, then I know that ahead of time. Just like as a plaintiff's attorney, when you have my insurance policy, as a defendant, you're going to know if I have an excess insurance coverage provision and such that maybe that excess insurer needs to be participating in that mediation. It's the same to me. It's just to understand who the stakeholders are so that when you go into those types of conversations, you know who might have a voice in the decision that's being made.
But I guess the issue is if the provisions of this bill become law, they would not have a voice in the decisions being made.
Again, we would hope.
Do insurance if let's say an insurance company represents a truck driver, do they get to make all the do they then tell the lawyers what to do for the truck driver?
I am not aware of any insurance policy that says that the insurer tells the lawyer what to do. However, the insurance policy often does control choice of counsel, so the truck driver may not have the ability to choose his or her own defense attorney by the terms of that particular insurance policy. It also might determine what attorney's expenses are covered by the policy versus what are not covered by the policy. So when the truck driver has an insurance policy, some of their defense costs may or may not be covered by that policy. And so those may be similar issues to what might be in a third-party litigation funding agreement. I don't know. But in addition, I would hope that funders always do the right thing. And if Georgia passes SB 69 and it precludes funders from having control, I would hope that they honor that. But I happen to have experienced in my 57 years on this earth, sometimes people not telling the truth and not doing what they should be doing. And the only way to make sure that people are doing what they're doing is to have transparency, disclosure, and discoverability.
I don't disagree with that, and I'm not trying to encourage you to filibuster here. I'm just trying to make sure I understand what the rationale is, and I think you enlighten me, and I appreciate that. But have you ever seen a third-party financing contract where that provider of financing requires any participation whatsoever in the decisions of that litigation? Have you ever seen an agreement like that?
I've seen agreements, again, not in the state of Georgia, but I have seen agreements where, in fact, the plaintiff's attorney was a part owner of the funder.
Oh, that's interesting. My question is this, though. I just really want to know, because I'm trying to drill down to the actual issue here. Have you ever seen an agreement itself, what you want produced, that allows the third-party financier to make decisions about litigation?
In litigation, not that I've been involved with, but in litigation that has gone on in other states between consumers and funders, that has existed, yes.
What states would those be?
I could get you copies of those cases. That's not a problem.
Thank you. Thank you, Mr. Chairman.
Thank you, Chairman Newton.
Just a quick
Yeah,
follow-up
sorry,
on
I'm
that. You
sorry.
mentioned about the discovery of an insurance policy for a professional of some sort. I do know that we all face this, there's a consent to settle clause that you may or may not have in your policy, which is discoverable and shared with the
Right.
plaintiff. And there are times if the insurance company can settle without the consent of the provider, that's in that documentation, and the plaintiff's side would learn that, correct? And then, but by the same token, if you looked at that policy, if you were representing the plaintiff and it said it did not have that consent to settle agreement for the insurer, then you'd know that the only person you had to go to was the provider themselves. Is that right? So that's
Yes.
the kind of thing you'd like to find out in the reverse when it comes to the prosecution
Exactly.
or plaintiff.
Yes.
Okay, thank you.
Yes.
All right, thank you. Thank you for your testimony today.
Thank you.
Is it Rochelle Mortimer? Good afternoon.
Thank you. Can you hear me okay? Okay. Thank you, Chairman Leverett. Thank you to the members of the subcommittee for giving me the opportunity to present before you today. I'm here to support SB 69, and I won't take up too much of the committee's time. I just wanted to highlight a few of the provisions that we think will be really helpful for legal reform. And we have been looking at this issue for over a decade, studying the transition that the litigation financing has gone through. So the industry actually started over in Australia and slowly migrated into other countries. But an interesting fact about litigation financing that some researchers have found is that a lot of the litigation financing market right now is actually located in the United States. So some estimates are that about 50% of the market is in the United States now. So the reason that, the Institute for Legal Reform has concerns about this type of funding is, as people have mentioned before me, so I won't go too deep into it, are some of these control aspects, conflicts of interest, concerns about how this litigation financing can affect the course of litigation, what suits are brought, how long they take, settlement, etc. So I think some of the provisions in SB 69 that will be really helpful, especially on the consumer protection side, are that elimination of control over any of the litigation, because there are instances that we've seen of litigation financiers trying to insert themselves into litigation to take control. And I think one important part of that is that this bill actually makes sure that the claimant themselves is aware of the litigation financing and is aware of their right to control their litigation, and that the funder has no ability to take that sort of control away. Another concern that ILR has that I wanted to point out that this bill addresses is some of the foreign investment in litigation financing. So this is a concern that we raised several years ago, and we have, through investigations in the last several years, come to see several examples of this being a problem in the United States. There has been investigations or concerns expressed by the U.S. Department of Justice as to certain types of this sort of foreign investment in litigation financing. Two litigation financiers that we know of have investments from sovereign wealth funds that are undisclosed. And we have seen cases where a Chinese funder is funding litigation in the United States, particularly in the patent space, and that was not disclosed except for an investigation that was undertaken that revealed that funding. But at the moment, we have no way to know if there are other sorts of these types of funding in the litigation. One concern that was expressed by DOJ was that these types of litigation, this foreign litigation funding, could be used to, compete essentially with United States businesses. So litigation obviously takes up a lot of resources and time for a business. So if you're a competing business in a foreign country, if you invest in litigation against that competing business, it might make it harder for them to invest in research and development, invest in hiring employees, things like that, that would give you a competitive advantage. Again, I really appreciate the committee's work on this, and I would just say that we would like to support SB 69, and I'll stand ready for any questions.
All right, thank you. I don't see that you have any questions. Thank you very much. Phil Goldberg. Good afternoon, sir. Podium mic's on when you're ready.
Great. Well, thank you, Mr. Chairman, members of the committee, for having me today. My name is Phil Goldberg. I'm a partner at the law firm of Shook, Hardy & Bacon in our Washington, D.C. office. And I spoke this summer with the National Conference of State Legislators about litigation financing and because of the impact it's having on our civil justice system. And I was asked to testify today by Georgians for Lawsuit Reform, which, as many people here know, focuses on ensuring a fair, balanced, and efficient legal climate for all Georgia citizens. The basic premise, and I think we heard the speaker before me talk about this, is that this is new. This is completely new. This did not exist 15, 20 years ago in the United States. When I went to law school, I didn't know, when I took all the torts classes and all of that, they never talked about litigation financing being the driver of a lot of mass tort litigation. But that's what's been happening over the past few years. It's, as Professor Maya Steinitz, who's one of the leading academics on this, has said, it changes every aspect of civil litigation. Which cases are brought, how long they're pursued, when they are settled, all without transparency. They're operating in the shadows. And so this legislation will change that in common sense ways that are focused on protecting the courts and, importantly, the parties, both the plaintiffs and the defendants. There's a little bit of a misnomer here about the litigation financing. It's litigation investing. These are hedge funds, institutional investors, and others who have figured out how to take advantage of the access to justice that our courts rightfully give people to bring lawsuits and try to seek recompense for being harmed. Today, as we heard, it's a $15 billion industry in the United States. Estimates are that it'll get to $31 billion by 2028. In the mass tort space, you regularly see $50 million loans to law firms. Some have been reported to be $200 to $300 million. But there's no legal structure for all this new investment, for all of this new impact on litigation. There's no structure. There's no regulations that protect the integrity of the litigation process, from including things like basic disclosures. So this legislation, I hope people appreciate, is not about stopping TPLF. It's about protecting the courts and the parties from the TPLF abuses. And it's maintaining access to justice for both the plaintiffs and the defendants. Sometimes, as the speaker before me alluded to, the plaintiff doesn't even know their case is subject to one of these agreements. The defendants don't know who they're settling with, who they're litigating with. The courts are supposed to be about allowing these defendants and these plaintiffs to come together. They've got a dispute. They're trying to go to the courts to get a peaceful resolution of it, and they need to be able to do that without someone saying, looking at this solely as an investment mechanism. In the mass tort space, which is about 2/3 of where the litigation funding is going, what they do is they do portfolio funding. They underwrite entire litigations. It's been called the vendorization of mass torts. When I was on a panel last year on this, the funder actually was saying that she thought it was a good thing that they're basically in partnership with their law firms, and that was one of her selling points. So this is very different than I think some of the things that we've been hearing today and some of the concerns. These are different sets of concerns. One of the things they do is they drive a lot of the TV advertising we see. So it's $6.8 billion in advertising from 2017 to 2021. Report came out a couple weeks ago that in 2024 there were $2.5 billion in lawsuit advertising, up 32% from 2020. And I'm sure you all here see it every day as we do. Their goal is to make litigation too big to fail, to try to get 25,000 plaintiffs, 50,000 plaintiffs to sign up. That's a completely new thing that's never happened. But this mass of lawsuits doesn't mean there's truth to any of the claims, because what they're trying to do is they're trying to litigate the mass, not litigate the merits. And so you have the Federal Rules Advisory Committee saying that there's a widespread agreement among lawyers and judges that up to a third or a half of all of these claims don't have merit. That the plaintiff can't show they use the product that they're suing over, that they can't show they have the disease that they're claiming that they have. And because there's no vetting of these claims, because no lawyers can go through all of these, and they often don't even know, the plaintiffs don't even know who their lawyers are. And so the judges are frustrated because they'll say to the lawyers, work up these 20 cases for a bellwether, and we'll see what happens. And regularly, a third to a half just get dismissed, voluntarily dismissed out of hand because there's nothing there. At the end of the day, you can't settle, you can't try 25,000 cases. So you end up where litigation admittedly has had no merit. There's one case from a few years ago over a medication where it resulted in a $775 million settlement, even though all the bellwether cases ended up in defense wins. But it was too big to fail, and the court said, we got to get rid of these cases. So these are funding lucrative lawsuits. They're not funding good lawsuits. And so I know my time is short, and I just want to make a couple of final points. Without the basic disclosures, we are seeing, and there are stories that we've seen. Cisco was one where the funder, that Cisco came to an agreement with the plaintiffs, with the defendants. The funder that gave the law firm and Cisco money came in and said, nope, not good enough. We want this litigation to be a baseline for future litigations. We're not accepting that settlement. And they actually had to come in and try to step in Cisco's place to litigate the case, because Cisco's like, we're out. We want to be out of this. We want to settle these cases. And the opinions from that case talk about how the lawyers were really doing the funder's bidding, not their client's bidding. When you're in the mass tort space, where the funder is driving the litigation and the plaintiffs don't even know who they are, who the lawyers are, who do you think the lawyer's going to be paying attention to and driving, and whose interests they're going to be focusing on? So so we see the conflicts of interest like that, the ulterior motives, and some of the privilege issues that were alluded to earlier in terms of the private information of the plaintiff's medical records and the confidential information of the defendants are being turned over to the funders because the funders want to see this in part of estimating the cost and their investment. So this legislation helps solve a lot of those problems. Brings TPLF out of the shadows. Reputable companies, we heard earlier, value the idea of being part of a regulated industry. Requires disclosure upon request of the parties, prohibits funders from controlling the litigation, makes so the funder can't get more to the judgment than the plaintiff, and then it bars the sovereign wealth funds. Finally, this allows people to sue when they are injured by someone's malfeasance, but it protects the system from this outside abuse. So thank you very much, Mr. Chairman.
Thank you for your testimony. Appreciate it. And I don't see any questions, so I'm going to go ahead and close the receipt of testimony. And ladies and gentlemen, I know I am known for these marathon sessions without a break, but I'm going to take a break now. You can thank Chairman Newton because he was kind enough to give me this water earlier. So let's take about a 10 or 15 minute break, and then we'll reconvene to discuss the bill. All right, if anybody's out there in the hall, if you'd come on back in. We have our members on here. I think Stan is still outside. Okay, there it is. Patience. So what I'd like to do is I'd like to put the sub before us, and then I have a proposed amendment, and then I'd like us to have any discussion we need to have, and then take a vote. So we've got a substitute before you, which is LC 492382 ECS. Do I hear a motion do pass on the substitute? I hear a motion and a second. All right. And now as far as amendments go, the chair would like to entertain a motion to make 2 changes to this substitute. One of them on line 267, which is on page 11, I believe, to add, after the word services, to add the words related to the litigation, to narrow the scope of that prohibition. Because some of the companies that do this kind of stuff also provide financial services that would not, impact the litigation necessarily. I'm sorry? Related to the litigation, right after the word services on line 267. And then the other one, which we can refer to as the Evans-Aunt Sally Amendment, is to strike the word regulated on line 384. All right, so we have striking regulated on 384 and adding related to the litigation after the word services on 267. All right, do I hear a motion to make that amendment? We got moved. Do I have a second? I got a motion and a second. All right, any discussion about the amendments or the substitute? All right, hearing none, I'll call the question on the, let's see, make sure I get it right. We call for the question on the amendment first, and then we vote on the bill as amended, correct? All right. I know you've got my little script here, but I wanted to confirm it with you in case I was reading something wrong. All right, so we've got a motion to amend on the floor with a second. I don't think there's any further discussion. All those in favor of the motion to amend the bill signify by saying aye. Those opposed say no. All right, the ayes have it, and so the substitute is amended. Now all those in favor of recommending do pass to the substitute as amended, would you signify by saying aye? Aye. All those opposed? Do you have a question?
I do apologize. I was reading as you were moving swiftly. I did want to propose one small amendment for the subcommittee's consideration. It is on line 274 of the substitute. A litigation financing agreement shall. My proposal, based on some of the discussion I had and what I've sort of already said on the record, I propose shall be changed to may.
Okay.
I think the chairman understands why, but I will just say it for the benefit of my colleagues. I think that if a litigation financier does everything he or she is supposed to do under this bill, and let's say a legal representative, based on that legal representative's conduct unrelated to the financier, could be held responsible for decisions in the litigation when they are at the same time prohibited from participating in the litigation. So I think that's sort of contradictory in this code, and more importantly, I think it would discourage good litigation financing companies who do everything that they're supposed to do from engaging in this endeavor, which does, as we've already discussed, provide benefit to plaintiffs when done correctly, plaintiffs who need assistance bringing their claims. So I would ask the chairman to consider changing shall to may.
And I think we had we discussed that issue, and the chair would, I think the chair tried to offer a contrary position, but I will allow that motion. So if you want to make that motion.
I so moved.
All right, is there a second? All right, is there any discussion? All right, all those in favor signify by saying aye. Aye. All those opposed say no. No. All right, let's have a show of hands. Those in favor, raise your hand. Help me do my ciphering. That's 4. All those opposed? I think the motion fails, correct? Okay. All right, so are there any other motions? All right, so we've got the motion to pass the bill as amended with the, I'll just collectively refer to that as the Aunt Sally amendment. And the motion and second have already been made, so they're on the floor. All those in favor of passing the bill as amended in that manner signify by saying aye. Aye. All those opposed say no. No. No, we had 1 no, I think. Okay. The chair says the motion passes, and so we will recommend due pass to the full Rules Committee on that substitute as amended. And that, ladies and gentlemen, I believe concludes our business for this evening. So thank you all. Now, hopefully that will conclude our business as a subcommittee. I just want to thank all the committee members for your service, and want to thank all the folks who attended so patiently throughout the hearing. So thank you, and we're adjourned.